Good afternoon. Welcome to Criminal Justice Full. We are glad you are here. There's lots of places you could have gone this afternoon, and you came here anyway, so we are very appreciative of it. Let me get some old business out of the way. Last week, when we announced all the folks that are working on the staff side of this thing to keep things running well, I did not mention Gabby Hamada. Would you raise your hand, Gabby, and let us make you welcome? Okay, committee, are there any general orders before we take the roll? Personal orders. All right, we have none. Clerk, would you please take the roll?
Representatives Carringer, Davis, Doggett, Farmer, Fritz, Glenn, Hardaway, Howell, Johnson of Knox, Lamberth, Moody, Russell, Towns, Vice Chair Gillespie, Chairman Holsey.
Here.
Mr. Chairman, you have a quorum.
Thank you very much. All right. First up today, we might as well get started so we can get out. First item is House Bill 1021. As a correction, it's House Bill 1628 by Chairman Sapicki. You have a motion and you have a second. Chairman, you're recognized.
We are working off an amendment, Mr. Chairman.
We do have an amendment. It's not the number one, it's the number two amendment.
Drafting code 012403.
That's what I have. There's a motion and a second on the amendment. All those in favor of the amendment say aye. Opposed, no. Ayes have it. The amendment's on the bill. Now, would you please explain the bill as amended?
I will, Mr. Chairman. I must say thank you to the chairman of both the sub and the full committee for helping me work on this over a year. What this bill does is we have a problem with assault in our healthcare facilities, on our healthcare workers and everybody who works in facilities, from doctors' offices to our emergency rooms. People trying to help other people are being assaulted at record numbers in the state of Tennessee. And what this does, Mr. Chairman, is it basically makes an enhancement there that if you assault somebody or aggravate assault somebody in one of our healthcare facilities across the state of Tennessee, there'll be an escalation to that. In the amendment, Mr. Chairman, it does two key things. The first one is, and I'd like, with your permission, sir, to read this into the record. We're going to rename this the Dr. Benjamin Mauck Act. And also in the bill, it has some clarifying language about the healthcare facility. It means the portion of an institution, place, building, or office devoted to providing healthcare services as defined in 5661-102 and includes the reception and administrative areas of the facilities. And with that, Mr. Chairman, I'm going to read this letter from the Mauck family. And I'll be married in my 5 minutes, sir. Written by Amanda Mauck and Rebecca Gentry, sisters of Ben Mauck, on behalf of his parents Gregory and Ann Mauck, brother Samuel Mauck and his wife Rhiannon Mauck, and his two small children. How do you find words to express the raw pain and deep, profound sadness you feel from the loss of a sibling in such a senseless way? To say that it is life-changing really doesn't do it justice, and the toll it will take on all of us who loved him will never be fully realized. Dr. Benjamin Mauck stood 6'7" tall. And in his signature cowboy boots, he rose to over 6'10". His size immediately gave him presence when he walked into a room, but it was his spirit that endeared him to those around him. Ben was kind, generous, funny, supportive, and most importantly, protective. In his life and ultimately in his death, he protected those he loved. He loved fiercely, and if you needed Ben, he was always there. He took care of those around him. After his death, there is a sense of calm and contentment that we will no longer have. We all now feel anxious being part of the world around us. The evil circumstances that took our brother's life is an omnipresent reality. On July 11th, a patient walked into his exam room, pulled out a handgun, and shot Ben at point-blank range 3 times in the chest and neck. Within seconds, my family's world was ripped apart. A week prior, the same patient verbally threatened his life and the lives of his fellow colleagues, but on that fateful day, Ben did what he knew to do. He calmly saw the patient, hoping to heal the pain while trying to protect the others in the clinic. In a few months, the prosecution of his killer will begin. Details of the movements of Ben's murder will come to light, and from the courtroom, we will relive the events of July 11th over and over. His sister, Becky, is also a healthcare provider, and she says, "I go to work each day with what happened to him constantly on my mind. I have had moments when I find myself looking over my shoulder, taking second looks at the entrances to the facilities, continually worried about who may be walking through the door. I have had moments when it has been difficult to contain my emotions. I have had patients that have scared me to the point I could no longer provide them care. Since Ben's death, our family has wrestled with trying to understand why he was taken from us so senselessly and why the systems put in place to keep us safe failed him so tragically. We've experienced the first of his absence, and with each milestone, our hearts break for him over and over. Ben excelled in everything he put his mind to his entire life. He lived his life with purpose. He never wasted a moment. He was a great human being, and the light of the love he brought to our world is gone. That gaping 6'7" hole in our hearts will never be fulfilled. In passing, our hopes is that this tragedy will have endured, is never experienced by another family. We support the Tennessee Medical Association, the Memphis Medical Society, and urge the Tennessee State General Assembly to pass the Dr. Benjamin Mock Act and extend protections to physicians and those who work in healthcare facilities. Mr. Speaker, I stand ready to answer questions. Mr. Chairman, I stand ready to answer questions.
Thank you. Questions from committee, Vice Chair Gillespie.
Thank you, Mr. Chairman. And Representative, thank you so much for bringing this, and thank you for renaming it. I actually had the privilege to be treated by Dr. Mock, my hand, an injury a couple years ago. That was the only time I ever met him, at least that I know of, but really affected our community, my community, and I just wholeheartedly support this legislation. And again, I just want to thank you very, very much on behalf of all my constituents and the surrounding area.
Thank you, sir.
All right, any other questions for the sponsor? Representative Carringer.
Not a question, but just a couple of statements. Thank you, Chairman, and thank you, Representative, for carrying this bill. Just last week, the University of Tennessee Medical Center had a CNA who was pretty close to being strangled to death by a patient. So this is a very real problem that every state and every county is having in their hospitals and offices. That we don't hear about all of them because it doesn't make the news unless this. And one of my husband's partners was good friends with this doctor, and talked what a wonderful person he was. And I just, it's sad that we are having to talk about this, but it is a real situation, and that medical people face every single day. And so thank you, and my condolences to his family, and I'm just so sorry that we're having to talk about this, but thank you, and prayers with his family.
Representative Johnson.
Thank you. And I just want to clarify something. So it's anybody who happens to be in the hospital? Is it just employees in the hospital? I came in a second late, forgive me.
Mr. Chairman,
Yes, sir.
it deals in the assault in the facility.
Okay,
So,
so
facility.
anybody, thank you.
All right, any other questions for the sponsor of the bill? Representative Hardaway.
Thank you, Chairman. Good afternoon. Excuse me, to the sponsor. This doesn't change anything in terms of, let's say if it was the psych ward or something like that, there's still the not necessarily safeguards, but there's a process that will address those who have mental challenges. Those safeguards are still there.
I guess, I'm sorry. Thank you, Mr. Chairman. Could you ask the question? I'm not familiar with the question you're asking.
Let's say that it was a psychiatrist who was treating a patient,
Mhm.
and that patient had some serious disorders.
Mhm.
How would that be handled?
According to the way the bill's written, if it's in the facility and it's an assault or an aggravated assault, then the escalation could apply.
Any of the defenses that a mentally challenged person would have in a similar situation outside of the hospital, they would still retain.
I guess we could go to legal on that and that's more of a clarifying question from legal, Mr. Chairman.
All right. We'll go out of session and ask legal.
Michelle Fogarty, Office of Legal Services. Any of the defenses currently in statute that would apply to other criminal offenses would apply to this one. So they would have the same defenses that they have for any other criminal offense.
All right. Thank you, legal. Thank you, Chairman. Thank you, sponsor.
Any other question for legal while we're here? All right, we're back in session. Any other question for sponsor of the bill? All right, question been called on the bill. We're ready to vote on House Bill 1628. All those in favor say aye. Aye. All opposed, no. Ayes have it. Mr. Chairman, it moves to finance.
Thank you, Chairman of the Committee.
That brings us up to item number 2, House Bill 1641 by Leader Lamberth. I have a motion and a second. Leader, you're recognized.
Thank you, Mr. Chairman, and very straightforward. If an individual is in violations of their bond conditions and an officer has probable cause based on the information that they have personally witnessed or gathered, then they can charge that person with a new A misdemeanor for violation of bond conditions. Now, this can be a cite, it can get him back in court that way, or it can be an arrest, depending upon how egregious the circumstances are. I stand ready for questions, Mr. Chairman.
All right, you've heard an explanation of the bill. Any questions for the sponsor of the bill? Representative Johnson.
So I guess my one question would be, that we're setting somebody up to have a second, violation, correct? Is that right? Whatever they've done to violate, is that like if they've committed a crime to violate, or can it be being 2 minutes late as a probation concern?
Yeah, this is, in most of these, what it's going to be included is going to be your domestic violence circumstances. So when someone has a no contact order and you have someone who is arrested and accused of, say, aggravated assault, it is alleged that they have abused a partner, a roommate, a family member, many times in those circumstances, especially if it is a repeat domestic violence incident, they will order that that person have no contact. Well, as you could imagine, some of those abusers continue to try to reach out to that victim and can convince at times the victim to allow them to be back in the dwelling with them, back in the vehicle with them. Well, if an officer stops that car and knows, because maybe they've handled the original case, but they have to actually know that a bond condition is no contact, and then they stop a car, it is, to me, crazy that they could just let that car drive off. We had in our jurisdiction, this very circumstance occurred where a man was on a no contact order and was in the vehicle with the woman and shot and killed her right in front of her children. And so it's for those circumstances where it's not 2 minutes later on a visit with probation because they're not on probation yet. It's when they're in violations of that bond condition where they're literally, I mean, it's like a no contact, or you can think in a repeat DUI offender. If they're ordered not to drink and an officer walks into a bar and there sits little Johnny who's got a pending DUI fourth and has been ordered not to drink and he's sitting at the bar having a beer. That type of thing would be a new A misdemeanor for the new action of violating that bond condition.
I understand that, but a bond condition could be you have to be home from work at 7 o'clock and you get home at 7:02, and it could result. I mean, it's not going to be a domestic violence situation every time. There are other situations that could arise that would fall under this as well. And that's my concern.
I don't envision, especially in that circumstance, that an officer would even be aware of something like that. Now, if you have a repetitive issue where there's evidence of that, the goal is to get this back in front of the judge so that violation of bond conditions, I mean, it can be punished already if someone is guilty of this with contempt of court. It can resort in a revocation of bond under current law. We're just saying, look, this is a new A misdemeanor, that an officer can act upon it if it's occurring, that they have knowledge of it occurring in their presence.
I just have concerns about all of the conditions, and that you can violate a condition of bond that is not another crime. And that is the concern.
All right, any other questions for the sponsor? Representative Hardaway.
Thank you, Chairman. And to the sponsor, this is merely for, and I'm keying in on protective orders. That protective order would have to be a condition of the bond. It just couldn't be a protective order out there by itself.
Yes, sir. I mean, those protective orders are a totally separate circumstance. This only deals where, a magistrate or a judge has put down a specific condition of bond and has felt that it's important enough for the safety of either a particular victim or the community to put down a bond condition. And an officer has to have a probable cause that an individual has violated that specific bond condition.
All right. Thank you. Thank you, Chairman.
Any other question for the sponsor? All right, seeing none, we're voting on House Bill 1641. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. It moves on to finance.
Thank you, Mr. Chairman, members of the committee.
All right, we are now up on item number 3, which is House Bill 1642, also by Leader Lambert. There's a motion and a second. Leader, you're recognized.
Thank you, Mr. Chairman. And this is kind of in the same topical area on bonds, but this would ensure that public safety is the first consideration when setting bond. It has some little housekeeping things as part of it, but that is the primary issue, is that it's going to say, look, when setting a bond, there's a list of conditions that shall be considered, but public safety is going to be the first and foremost one. And with that, Mr. Chairman, I stand ready for questions.
All right, you heard an explanation of the bill. Any question for the sponsor? Seeing none. We're now going to vote on House Bill 1642. All those in favor say aye. Opposed, no. Ayes have it. By the way, if you want to register a no, see the clerk, please. This moves to calendar and rules.
Thank you, Mr. Chairman, members of the committee.
All right, we're now on item number 4. Is House Bill 1643. There's a motion and a second. Sponsor, Leader Lambert, you're recognized.
Thank you, Mr. Chairman, members of the committee. This bill is a bill that I carried during the special session, and unfortunately it did not pass both chambers and get to the governor's desk. But 15, 20 years ago, the state of Tennessee would pay for a mental health evaluation for both misdemeanors or felony offenders who are alleged to have committed a crime, and their lawyer brings to the court's attention that they need a mental health evaluation to determine whether they suffer from severe mental health issues. Unfortunately, in a down budget year, the state of Tennessee stopped paying for evaluations for misdemeanor offenders, and that has really caused havoc amongst the court system for some of these folks that really need an evaluation, because the local communities are paying for some of them, but definitely not all of them. This would save the locals about $1.3 million a year and would cost the state of Tennessee about $3.3 million a year. As you can see by the exchange of the funds there, you're going to roughly get 3 times as many mental health evaluations done. In my humble opinion, that is a very good thing. More information in the judicial system is always better. And if someone has a severe mental health issue, that evaluation needs to be something that is brought to the court's attention. That is all this bill does. And this would affect approximately 363 people a year. But that's 363 folks that really do need these evaluations. So with that, Mr. Chairman, I stand ready for questions.
Okay, you heard an explanation of the bill. Any questions for the sponsor? Representative Hardaway.
Thank you, Chairman. First of all, it's not a typo. I'm on that bill. And second of all, this is a case of where we're curing, where we've been penny wise and pound foolish. Is that simple? So thank you, sponsor.
Thank you, sir.
Any other questions or comments for the sponsor? Question been called on the bill. We'll vote on House Bill 1643. All those in favor say aye. All opposed, no. Ayes have it. Bill moves to finance.
Thank you, Mr. Chairman, members of the committee.
And the remainder on Leader Lambert's calendar is item number 5. There's a motion and a second. House Bill 1663. Leader, you're recognized.
Thank you, Mr. Chairman, members of the committee. And during the snow week, I had some extra time, so I basically took almost most of my bills, probably easily half of them, and we didn't put them on notice. So I do have several bills on the calendar. Apologize for that, Mr. Chairman. This bill has really been many years in the making. So, and I think everybody on this committee knows that I'm a former prosecutor and have several friends that still work in that job. And over the years, I have had dozens and dozens of survivors of rape, either while they were a child or an adult, that have come to me and ask, is life in prison all that is available as a punishment for these horrendous monsters that have raped children? And unfortunately, because of a U.S. Supreme Court case from several years ago, which I am hopeful they would overturn if we were to pass this bill, juries are no longer in the state of Tennessee allowed to evaluate the aggravating factors that you will see in this bill, so that the worst of the worst, not even every single rape of a child case, but the worst of the worst where there are enhancements like multiple victims or significant criminal history or particularly vulnerable victim, so that the worst of the worst, a jury would be able to make a determination that that individual, through their choices and the defendant's actions, would forfeit their life and face the death penalty. I've talked to child advocacy centers throughout this state. I've talked to victim advocates throughout this state, and you will get folks that are strongly in favor of this bill and folks that are strongly against this bill. This is a policy determination for you all as the elected voice of the people of Tennessee and of your districts to determine, are there a few cases out there that are simply so horrendous that for someone who is convicted of rape of a child, should they face the death penalty? In my personal opinion, the answer to that question is a resounding yes. Many of you on this committee have received hundreds of emails over the last several days. I didn't ask for those emails. I didn't push for those emails. Those are Tennesseans that are reaching out to you on their own. I have a specific email here. There was one I read last week, but there was a very brave young lady that came into my office a couple of years ago. And I was one of the first few people that she shared with what had happened to her. And I got an email from her, and I won't reveal her name right now, but just got an email a few days ago that her parents, her family members, her friends, she just thanked me for bringing this bill, because she said that in her opinion, not mine, but in hers, it will save some children from having to go through this absolute horror. And that, to me, is worth it. And to me, the punishment should always fit the crime. And if you commit this type of crime, the punishment should be the worst that the state of Tennessee could possibly have to offer. With that, Mr. Chairman, I know we have some testimony, but I stand ready for questions.
All right, that's an explanation of the bill. Before we get into discussion from the committee, we have three folks here who came to testify on this bill. Holly Gallion from Our Kids Center, Preston Ship from the Campaign for Fair Sentencing of Youth, and Sarah McGee from Tennessee Association of Criminal Defense Lawyers. If you three folks would like to come up to the table at the front. We will go out of session. And if you'll find a button on your microphone there, get a red light. You each have 3 minutes. And at the end of that, when you're through, then we'll be open for questions from the committee for your responses. Okay, you are recognized.
Would you like me to start, sir?
That's fine.
Can you hear me?
Yes, ma'am.
My name is Sarah McGee. I'm an attorney here on behalf of the Tennessee Association of Criminal Defense Lawyers. I currently serve as the coordinator for a nonprofit that seeks to reform Tennessee's death penalty. I have served as a victim witness coordinator for the Davidson County District Attorney's Office and as a probation officer. I have also served as an assistant public defender for youth and adults. I am the mother of 3 young children, and I take this legislation and my testimony very seriously. First, I want you to know that this bill would apply the death penalty to people in situations you might not have considered. This is a hard thing to discuss, but we are talking about the government taking the life of an individual, so I feel the need to raise some examples. Rape of a child includes actions other than forcible penetration. It includes oral sex and digital penetration, either by the victim or upon the victim. Force is not required. An 18-year-old with any serious mental impairment who doesn't qualify as intellectually disabled could be executed for these non-lethal crimes of a sexual nature. Even a 12-year-old experimenting with another 12-year-old could serve 40 to 60 years at 100%. Since 90% of these crimes are committed by family members or people in the child's circle of trust, this means that these already traumatized children will be forced to name a loved one who could be executed if found guilty. Second, the death penalty carries the inherent risk of executing an innocent person. And since 1972, 196 people have been exonerated from death rows because of wrongful conviction. If you expand the pool of potential capital defendants to include non-lethal child rape, you substantially increase the potential for wrongful convictions. Studies show that false accusations by children who may have been coerced into the accusation have occurred, which can lead to wrongful convictions of innocent people in some cases. If those individuals are executed, the damage cannot be undone. Third, though it has been suggested that the death penalty will deter this crime, the overwhelming research on the death penalty does not support this suggestion. But for the sake of this hearing, if you subscribe to that belief that the goal is to deter these types of crimes, you must also believe that the people who commit these crimes are rational actors who are making decisions in the moment about the possible consequence of their actions. And if that's true, this bill could potentially endanger the lives of child victims because the punishment is the same whether the child lives or dies, incentivizing the offender not to leave the witness alive. Finally, if the goal is to overturn established U.S. Supreme Court precedent, it is far from a guarantee. The amount of resources the state would have to spend, as well as the trauma to child victims during the process, cannot be overstated. To have a test case requires expending all the attendant costs that go along with an often decades-long death penalty prosecution, which in both Tennessee and around the nation have been shown to cost more on every level than the alternative sentences, as much as $2 million more per case. If even a fraction of those who commit child rape in Tennessee are charged capitally, there will be an exponential increase in the cost to the state of Tennessee over the course of the case. There are also the costs to the child victim who may have to return to court repeatedly for decades of litigation. Our resources are better spent on prevention or seeking to repair the harm for victims after the fact. Expanding the death penalty to child rape creates more problems than it solves. Respectfully, I encourage you to vote no on this bill.
Okay, thank you, Ms. Gallion. Mr. Ship.
Thank you very much. I'm Preston Shipp. I work for the Campaign for the Fair Sentencing of Youth, which is a national nonprofit. I live here in Nashville, so this was easy for me to come and be with you today. And the CFSY does oppose this bill. I want to focus on the juvenile component specifically, since that's our wheelhouse. And I think this bill attempts to answer a question that we've been wrestling with since the 1990s, which is, what do we do with kids when they cause harm? And in the 1990s, of course, Bill Clinton was in the White House. Then Senator Joe Biden sponsored the 1994 crime bill. Hillary Clinton was going around talking about super predators, which is sort of a new mythical young criminal who is incapable of remorse or rehabilitation. And we saw more and more kids get swept into the adult prison system for longer and longer periods of time. About this time, I started working as a prosecutor here in the Attorney General's office, and I was part of handing out some of these really, really long sentences to really young kids. But also in the 2000s, we started seeing the science of adolescent brain development that was confirming what parents have always known, that kids are not little adults, that they don't appreciate the consequences of their conduct in the same way, and risks and all the things that for those reasons, we don't let 18-year-olds vote or serve on juries or serve in the military or sign contracts or get married, because they don't have the same kind of judgment as adults do. And we saw states like Texas say, we're not going to treat kids the same way we do adults. West Virginia, 10 years ago, said that anytime a kid gets a sentence longer than 15 years, we're going to empower our parole board to look at them after 15 years and see who they have become. And since that time, it's not just Texas and West Virginia, but Arkansas, Ohio, the Dakotas, Wyoming, Utah. Lots of states have said, that we're not going to pretend like kids are as culpable as adults. I want to share a couple of quotes with you. In the Illinois Senate last year, Senator Don DeWitt said, "I consider myself a law and order Republican, but I also do believe in rehabilitation. If you believe that these convicted young people can prove they can become contributing members of our society, vote that people can redeem themselves." And Senate President Larry Alpoff in Ohio said something similar when they passed a similar bill, and even invoked President Trump and the First Step Act and said he believes in redemption. I believe in redemption, but it wasn't called the only STEP Act. It was the first STEP Act because there was a lot of damage from the 1990s that needed to be addressed. And I would hate to see Tennessee go back to some of the failed policies of the 1990s. Second thing I want to say very briefly, I know time is short. I want to reiterate that I'm concerned with respect to the juvenile component that this is going to catch people that we're not thinking about necessarily. Child rape does not require sexual intercourse. It doesn't require force or violence. This could be a 14 and a 12-year-old neighborhood kids doing stuff they shouldn't be doing, but if there's penetration, it's child rape. And now we're talking about a mandatory 40 to 60-year sentence. I appreciate it very much.
Thank you, Mr. Ship. We'll have folks on the committee be asking you questions so you can expound more on what you want to talk about.
Thank you, Mr. Chairman.
Let's see, Ms. McGee. Is that right? Oh, I'm sorry, Ms. McGee, you already spoke. Ms. Gallion.
Yes, thank you. My name's Holly Gallion. I'm the clinic director and nurse practitioner at the Our Kids Center. Our Kids provides forensic medical evaluations and crisis counseling for children when there are concerns of sexual abuse. We evaluate 700 to 800 children annually from 47 counties across Middle Tennessee. In my almost 24 years at Our Kids, I've personally evaluated over 6,000 children and testified as an expert witness in criminal proceedings over 130 times. The providers at Our Kids believe that the intent of the proposed law is to protect children and hold perpetrators accountable. Advocacy for the health and well-being of children is paramount to us as well. Our concern is that the law could have unintended negative consequences for the very children we are trying to protect. Research and clinical practice show us that 90% of children are sexually abused by someone they know, love, and trust. Last year, of the children we evaluated who were 12 years of age or younger, 70% were abused by a family member, father, stepfather, brother, abused by someone they love. Research also shows us that disclosure is a very difficult thing for children to do, and most do not disclose immediately but wait months or years to tell someone what is happening. Of the children we see annually, less than 100 are evaluated right after something happens. Most are seen much, much later. If Tennessee allows the death penalty to become a sentencing option, we as medical specialists in this field are concerned that the child will pay the highest cost. What weight are these children going to shoulder if they know the person they are disclosing about could be killed for their actions? The 11-year-old will know that by telling the truth about what's happening to her, she could be the catalyst for the death of her father. The 10-year-old boy feels responsible for the death of his grandfather. What burden are we placing on a mother to either keep the disclosure a secret and abuse continues, or to make the gut-wrenching decision to report, knowing the possible consequences when her son has abused her younger daughter? It's concerning to think how these decisions could affect the resilience of children and families for the rest of their lives. On a cold, rainy fall night, I examined an adolescent who reported sexual abuse by her stepfather for 10 years. 10 years. She didn't want to get him in trouble. She only wanted the abuse to stop. She told a friend, who told a teacher, who called DCS. It took her 10 years to tell. When we saw her, her mother had only known for a few hours, and she struggled to believe. How could this have occurred under my roof for a decade and I didn't know? Her story is not unusual. Would that child have ever come forward if she knew the possible outcome of her disclosure? Would her mom have kept silent because it already seemed too difficult to comprehend? We do believe that perpetrators need to be held accountable for their actions. We urge you today to think of the unintended consequences to children in passing this law. We fear it could create a monumental barrier to disclosure, a barrier to healing and protection. We must all think about the possible consequences of this decision, and we must not make it harder for children to come forward and tell their stories. Thank you very much.
Okay, thank you, Ms. Gallion. Are there questions from the committee to these folks? Representative Johnson.
Thank you, Mr. Chairman. In your experience, what is the most important thing for a child in terms of a positive outcome and future healing with this type of experience?
We see this all the time, and we talk to parents about it all the time. I think the number one things are when kids are able to tell that they're then believed and protected. I think that path forward for healing for them, knowing, and I see this over and over again, even when teenagers tell us, it's the first time I've said anything, and thank you so much for really believing me. I think it starts with the belief, and then the protection follows.
Do you believe that this bill accomplishes those goals?
my fear is I see every day kids that struggle and struggle to tell. It's super hard for kids to talk about this. So my fear is because most of the time they don't want to get the person in trouble. They still love the person most of the time. They don't love the sexual abuse, but they still care about that individual. So my fear is that the disclosures would be limited then. And if they do disclose, would a parent then come forward because they're afraid that their husband, their father, their grandfather could face the death penalty. So my fear is that there will be less disclosure and safety for kids.
Okay, well, thank you. Appreciate that.
Other questions? Representative Hardaway.
Thank you, Chairman. Excuse me. This is a tough one. And it's where I got to separate my feelings for, I guess, in essence, revenge from what makes good public policy and delivers justice. One of the things that really concerns me is I think it was Ms. McGee that spoke to the possibility of children being eligible for the death penalty.
Go ahead.
I may have kind of combined my points. I talked about an 18-year-old being eligible, but then the other part of the bill is increasing the penalties for those under 18 to be 40 to 60 years at 100%. Not the death penalty for juveniles, no, sir.
All right, I was having a discussion earlier about what would happen if a 12-year-old and a 12-year-old were involved in sexual exploration,
Mhm.
and it's interpreted as exploitation by one or the other or whoever the adults are that began to investigate. Can you expound on that?
Yes, I mean, just reading the bill, the definition of child rape, including any orifice, any kind of penetration. So children under 18 with someone who's 12, as young as 13, even 12, could be charged with rape of a child. And this is the penalty under this bill, the 40 to 60 years in prison at 100%.
Okay. All right. Thank you,
Thank you, sir.
Chairman.
Representative Johnson.
Yes, I forgot one question. What about siblings? I think I've taught 27 years and worked with emotionally disturbed kids, seen a lot, but there's also particular relationships. Sometimes it's with siblings, and I've seen this. And, are siblings going to report when they're both underage?
I would almost worry more about will a parent report, because how torn is that parent? She has one child that has just sexually assaulted another child, and those could be similar aged or very different aged kids. But I find that parents, moms and dads, really struggle the most with that because they want something to happen. They're horrified that a child in their family has sexually abused another child. So they're torn with, I want to protect the child that's disclosed, but I also love my son or my other child. And how do I do that? So I would worry that it would completely disrupt any sort of family moving forward if the death penalty was an option for that. Because we certainly see 10, 11, 12-year-old girls that are abused by older brothers or other family members in that age.
All right, any other questions for these folks? All right, seeing none, I thank you so much for
Thank you.
taking the
Thank you,
time to
sir.
come here.
Thank you.
All right, we are back in session, and Leader Lambert, you're recognized.
Thank you, Mr. Chairman. I should have done this while we're out of session, but I deeply appreciate the work that Our Kids does. And so I thank you for your testimony and share your concerns to make sure that these children are supported in every possible way. And look, I get it. This is an extraordinarily difficult bill, but I did want to publicly say that the work that you do is phenomenal. And thank you so much for the work that you do. So just thank you, ma'am. That's all I had, Mr. Chairman. I stand ready for questions.
All right, Representative Johnson.
I guess I don't know that I really have a question. We talked a little bit about it in subcommittee. I just want to say that we currently have life in prison without the possibility of parole, and I certainly support that. This is a heinous crime, and the perpetrator needs to be held accountable, and certainly standing for a life sentence without the possibility of parole is not standing with child rapists. But I want to be very clear that I absolutely support that. However, we are talking about kids' fear of reporting, and I have heard it over and over, and I've heard it from organizations. Sure, there are some folks out there, but I think we really need to inform people on what we're talking about. Life without the possibility of parole is absolutely available here, and I am terrified of us chilling reporting from kids that will be afraid to do that. And I think it's a disservice to those children. We can prevent it from ever happening again with life without parole. But the silencing of so many voices is dangerous.
Leader Lamberth.
Thank you, Mr. Chairman. Look, over 70% of children nationally do not disclose abuse within 5 years. 1 in 5 never disclose. Folks can make up whatever reason they want to vote against this bill and be against the death penalty for child rapists. But I, for one, am going to stand tall to protect our children and ensure that if a monster has committed child rape in whatever fashion, by the way, because to a child, it doesn't matter what fashion that rape came in, it is an horrendous violation of that child. That person has absolutely forfeited their own life because they committed this crime. So, committee, I understand and get this is a weighty bill and should be, but we have an opportunity to draw a line in the sand and say, in this state at least, these crimes are equal in punishment to murder, because that's what it is. It is murdering a child's innocence. It is taking all of that away from them the rest of their lives. And look, some of the survivors of this are some of the strongest people you could ever possibly meet to just get out of bed every day, to be able to go forward in life. And every single one of us, regardless of this bill, there will be bills later this year, there will be budget amendments, there'll be everything else. We need to make sure we support those survivors of these type of acts. But for these monsters that have committed, and we're only talking about a few of these folks, we're only talking about the worst of the worst. Read the enhancing factors that are in this bill. This will not be every charge of child rape. It just won't be. It will be just those that are the worst of the worst. And it's a bifurcated hearing in front of a jury. So the jury has to determine guilt or innocence first. That's off the table. And then look at these enhancing factors and mitigating factors to see whether or not the weightiest penalty that a state could possibly. So, and I even understand those folks that may just be against the death penalty. I get that from a policy standpoint. I disagree with it, but I get it. But that's what this bill is about.
All right, Representative Davis.
Thank you, Mr. Chairman. So to the sponsor, does the DA's office, they still have the discretion to determine what charge they're going to bring. And so they're going to look at the facts of that case to determine whether or not it meets that standard, and they can prove that, the severity of that.
Absolutely. And in fact, there are quite a few, and I know there was an attorney that testified earlier, and there are several attorneys you can talk to about this. But throughout the entire process, if it's a death penalty case, even if you're getting a court-appointed attorney, you are getting the best of the best. You have to get someone who is death penalty certified. I mean, kind of the financial constraints that are on other cases are almost just thrown out the window in that. I mean, and that's a good thing. We need to make sure that if you are charged with an offense with the death penalty as a possible penalty, then you absolutely need the best lawyers, the best procedures, the best protections out there to make sure that the state never executes someone who is innocent of a crime. But that starts with the district attorney's office of fairly evaluating a case and making a decision whether or not to bring the death penalty. My district attorney, General Ray Whitley, is the longest serving district attorney in this state. And they recently had a case that was clearly a death penalty case. It was a person who murdered 8 members of our community. And that case actually, at the end of the day, settled on life imprisonment because of some mitigating factors that the defense counsel brought forward. Our district attorney made a very weighty decision in that, in conversation with the family and with others, to settle that on life in prison. And that went into it. I mean, the mitigating factors that the defense had brought forward with some developmental disabilities and some mental health issues and everything else, all that goes in. And you're only going to get those rare few who, with a clear mind, have committed these type of heinous acts.
Another question. I don't know many 8 or 10-year-olds that really sit around and read TCA and understand the laws that we have. Usually in a lot of these situations, they've been threatened that the perpetrator is going to kill that child or their family members if they tell. So that's usually a reason why a lot of children do not report these things. And so we have to factor that in too, that it's not just they're concerned about how their perpetrator is going to be impacted by that, whether or not they're going to go to jail or have any sort of death penalty sentence. They don't have that mindset in order to factor that in. They're thinking in terms of an 8-year-old child or a 9-year-old child or a 10-year-old child, and their world is their family, school, church, maybe some other friends or sports. And so they have no concept of the world at large. It is up to us to protect them and to keep at bay this evil. So I appreciate you bringing this bill.
Leader.
Amen, and well said. And I will, members, you received an email from Ms. Gallion that has some extremely important information in it. And in that has some information as to why children do not disclose. And while we're discussing this particular bill, please look at that, because there's a number of things just to educate yourself on why children do not disclose. Immature development at the time of abuse. It's really difficult. And it's hard for us to even think about this for a child as young as 2 or 3 or 4. You've recently seen this in the news. In other states where men who have committed these type of heinous atrocities against babies, little children, 2 and 3 years old. It's hard to believe we live in a world where somebody can do that. But how on earth can that child disclose? They're barely old enough to even understand what's going on in the world, much less something like that happening. So internalized victim blaming. A lot of these survivors, the first person they blame is themselves, that somehow or another, these twisted people convince them that they've done something wrong. These twisted, selfish adults have convinced these children that they've abused, that somehow or another it's their fault. And if you look at the email you got, I mean, it's on, I want you to look at this, because it's about this bill, but it's also about what our kids and everybody else deal with every single day in trying to get these children to a point where they feel protected and that they feel comfortable coming forward. But the mechanisms to protect oneself, sometimes that child has to get to a point where either there's a break in the family or there's services, or we've talked about SROs a lot in the legislature. A lot of times that is a person that some of these children feel safe at a school environment going to. And then look, there's specifically in the email you got, there's kind of circles, concentric circles, and I've gone with the ones that are barriers within, but there's other barriers without. There's social barriers, the taboo of sexuality. A lot of these children are around many of their peers that have not been abused, and it's very difficult for them to talk about this. Please look at that article that was sent, because it is extremely instructive to help all of us understand on the difficulty for these children.
All right, any other comments or questions for the sponsor? Representative Hardwick.
Thank you, Chairman. And for those who seem to think that you can't have a sensible, rational debate on this issue without standing with rapists, it's very offensive, and it's a lie. I stand for justice, and I stand for children. And the fact that there's so many dynamics at play here with the actual abuse and the reporting, the treatment for the child and for the family, the immediate and ongoing, lifelong consequences, the fact that there are systemic disparities in the justice system, that we're never 100% sure in some of these cases. And we have found out that we had the wrong person and put them to death, something, a deed that can't be undone. So you may not agree with my rationalizing, the way that I've arrived at my decision on this, but right now, I'm going to have to vote no, and that's in spite of those offensive signs that you have the nerve to bring up in here.
Are there any other questions for the sponsor? Leader Lambert.
So thank you for your comments, and I would never tell anybody in here how to vote on anything. I represent roughly 70,000 folks, just as you do. Each of us votes our own conscience on this in our own districts, and I respect that. I would ask folks to vote yes. I will passionately advocate for folks to vote in favor of this bill, but again, obviously, we all vote our own districts and our own conscience. And as far as the folks that are here that have signs clearly within our rules, I respect your ability to have signs here, and encourage folks to just politely hold those as they have. And we are perfectly comfortable with that here in the House.
All right, any other questions for the sponsor? Any other discussion? Question's been called on the bill. We're voting on House Bill 1663. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. Bill passes on to finance. That brings us to item number 6 on the calendar. That is House Bill 908. Do I have a motion? And a motion and a second. Vice Chair Gillespie, you're recognized.
Thank you, Mr. Chairman. I believe we have an amendment on this bill that is a friendly amendment that,
Okay, I agree with you. I'm showing amendment 006929. Is that what you have?
Yes, Mr. Chairman, thank you. And essentially, this amendment, with any of the revenues that are derived from the sale of a motor vehicle, that it goes to the state treasurer for the traumatic brain injury fund. And then also, I ask for a technical amendment attached to this, that we need to change the effective date. And so I ask that we were able to change that effective date to 2024.
Okay, you've heard an explanation of the amendment. We're now voting on amendment 006929. All those in favor say aye.
Aye.
All opposed, no. The amendment goes on the bill. Back to you, Representative Gillespie.
thank you so much, Chairman, and thank you, Representative Davis. I appreciate it. This is not the first time I've talked to you all about this. Drag racing, it happens all across the state of Tennessee, and unfortunately across the country. A lot of times it is done on public roads with innocent bystanders. I cannot tell you how many parents, aunts, uncles, grandparents have reached out to me over the last 3.5 years since I've been in the legislature, with their family members that have died, just simply driving down to the grocery store, not wanting to be a part of a drag race, not even necessarily knowing what a drag race was, but they're dead. And I've come before this committee and this body on multiple occasions to increase the penalty for drag racing and to create new offenses of aggravated reckless driving. Sadly, it's still happening. And I believe that if we, at the time of arrest and witness of the drag race, seize the vehicle, and a lot of times these are $70,000, $90,000 vehicles, that will send a message saying to people, do not drag race on a public street. Do not put people's lives in danger for your own pleasure. And what this does is exactly that. It will send a strong message saying, if you race on public streets in an organized fashion, we will take your car away. Pure and simple. And with that, I welcome any questions, and I appreciate the support of this committee.
All right, questions for the sponsor? Chairman Moody.
I was in Jackson, Tennessee, and was
not, I was on the outskirts of a racing event, but it was in a parking lot. Would this cover parking lots?
So it is, thank you for that question. And unfortunately, I've witnessed several instances such as that, both personally and on video. It's my understanding that the original language of the definition of drag racing applies to parking lots, private lots, any place that the public really is present. So I believe that would cover, but I would welcome turning to legal to ensure that's correct.
Thank you.
Okay, used to be DUI and reckless driving was the only thing you could enforce on private property, but we're going to go out of session legal.
Michelle Fogarty, Office of Legal Services. By statute, drag racing is any person who operates a motor vehicle upon the public highways of this state or while on the premises of any shopping center, trailer park, apartment house complex, or any other premises generally frequented by the public at large.
Okay, any questions for legal? Representative Hardaway.
Thank you, Chairman. Counselor, are there allowances for the fact that it might not be the operator's vehicle? It might be mama's car, or it might be a rental car, or it might be the company's car. Are there allowances for that in the bill or in current statute?
Michelle Fogarty, Office of Legal Services. The amendment says a motor vehicle used in the commission of drag racing is subject to seizure and forfeiture if the perpetrator of the offense is the sole owner of the motor vehicle and the motor vehicle is not subject to the interest of a secured party.
All right. Thank you very much.
You're welcome.
Any other question for legal? Okay, we're back in session. Chairman Doggett.
Hey, thank you, Mr. Chairman. And question, sponsor, is this civil asset forfeiture or is this criminal asset forfeiture?
Go ahead.
Thank you so much. It is on it's at the time of arrest. So.
Waiting on the chairman.
Go ahead.
At the time of the arrest, but is this a civil asset forfeiture or is this criminal asset forfeiture?
Go ahead.
Thank you. I believe, yes, it would be civil asset forfeiture.
Okay, thank you.
Representative Hardaway.
Thank you, Chairman. Can we get a comment from legal again on that? I think there's a different process for civil versus criminal in terms of the time and the method for forfeiture. So could we get a comment from legal?
All right, request to go out of session for legal. Go ahead.
Michelle Fogarty, Legal Services. This bill as amended allows for the forfeiture under the civil asset forfeiture proceedings.
And that does, will you help us understand the difference in civil and criminal? Would civil require a conviction?
Criminal asset forfeiture requires a conviction for civil asset forfeiture does not.
Thank you, Counselor.
Any other question for legal? All right, we are back in session. Any other question for the sponsor? Go right ahead.
I would just like to address that last question and just keep in mind that this is something that's taking place in real time. We're not talking about, I mean, yes, I guess under certain circumstances, there could be a police officer that's going in after the fact, but we're talking about drag racing taking place and arrests happening then. So it's not something that's being envisioned that, if that makes sense, that the officer is actually witnessing, or the bystanders, it's on like a video or something like that.
Chairman Doggett.
Thank you. Just clarification, drag racing is an A misdemeanor. In the event that there's a report of drag racing, a vehicle is described, two vehicles described, the description of the driver, maybe even a license plate number that would match that vehicle, and law enforcement agencies are not able to make contact with those vehicles at that specific time. They have 11 months and 29 days to file charges. I believe that is correct on a misdemeanor. 7 months from now, they find the investigation, they seize your vehicle, but you still haven't been charged because the vehicle matches the description that was provided to them by numerous complainants, perhaps. Maybe it was the driver. What is the mechanism? How do you make that determination in this process? Is it the vehicle? Is it the person that's driving? There's an entire year that could go by from the report to the time that charges could be made in this process. And being that it is civil asset forfeiture and not that of criminal asset forfeiture, can law enforcement agencies just show up and seize the vehicle?
Sponsor.
Thank you, Mr. Chairman. I believe there are rules already set up with the Department of Safety that monitors and regulates the civil asset forfeiture in other areas. So I don't know if, I know they're not on the list here, but there is a process already in place that this would apply to, similar to how drugs are processed in the same manner.
Chairman.
One of the things that last year we talked about, and I was hoping maybe that amendment would tie it to a criminal asset forfeiture, where there's a criminal conviction for drag racing, because there is, even with the scenario I presented, and then again, you may have a vehicle that you're caught drag racing on, you're arrested, the vehicle is seized, but you end up being charged with reckless driving or speeding or something totally different other than the actual offense of drag racing. In that event, do you get your vehicle back or is it gone?
Thank you, Mr. Chairman. It's my understanding that this is not like an instant process. It's not like you're being arrested for drag racing, a tow truck is called, and then the vehicle is sold 30 seconds later. It's not happening that quickly. It's my understanding that this is a drawn-out process, and there are appeals in place and checks in place that can take place if that does happen. But I will also note that because of the definition of drag racing and how it actually operates, the criminal prosecution of drag racing is that's the problem. It doesn't happen as much as it probably should be, because there are incidents of drag racing happening far more often than there actually criminal convictions or even charges being placed because of just the nature of drag racing.
Any other questions for the sponsor? Representative Hardaway.
Thank you, Chairman. I didn't have any until the explanation, but can you have a civil forfeiture for a criminal act? And that's to the sponsor or to Chairman Doggett or?
We'll go out of session for legal.
Or legal.
Michelle Fogarty, Legal Services. Under current law, drag racing, the motor vehicle used in drag racing can already be forfeited under criminal forfeiture. This would allow it to be forfeited under civil forfeiture. Civil forfeiture requires a forfeiture warrant, a forfeiture hearing, and then burden of proof of the elements of forfeiture by a preponderance of the evidence is on the state to prove that the motor vehicle was used to commit an offense.
All right, so this would not exclude criminal forfeiture, that the law enforcement or the prosecutor could go either way?
This bill amends the law to allow a motor vehicle used in the offense of drag racing to be seized and forfeited under the civil asset forfeiture part.
All right, so it doesn't impact the criminal forfeiture statutes.
There are no changes to the criminal forfeiture statutes.
All right, thank you, ma'am. Thank you, Chairman.
All right, any other questions for legal? Chairman Doggett?
I'm sorry, Mr. Chairman, I'm asking a lot of questions, but is it, with this bill, if it was to become law, could a person not be charged with drag racing and still have their vehicle seized?
You can, can't you? That's it.
That's a yes? Okay.
Just a preponderance of evidence.
With the preponderance of evidence?
Yes.
Thank you.
Any other question for legal while we're at? All right, we are back in sessions. Any other questions for the sponsor of the bill? Chairman Russell.
Thank you, Mr. Chairman. And how we used to do it is whenever we arrested people for DUIs, we'd issue a forfeiture paper. We had like 7 days to get it signed by a judge. And then once that's signed by a judge, they would give the date for a forfeiture hearing. The person would go and present their evidence along with the state's evidence, and that's how ultimately the vehicles would be seized under a DUI case. So something similar with this. So what the sponsor should be worried about is his driving on the way home to Memphis. That might be considered drag racing. So
Yeah, that is tied to a criminal asset forfeiture. All right, any other questions for the sponsor of the bill? All right, before we go any further, we've got to put an amendment on here, a minor detail, but we need to change the date, effective date to July 1st, 2024. So that was not included in your amendment, was it?
I asked for that.
Oh, I'm sorry. I did not know that.
I asked for that technical change when we voted on the amendment.
Mr. Chairman.
I'm sorry. Okay, okay, thank you. Somehow we missed it. Leader?
Mr. Chairman, on your advice, I would make a motion that any effective dates in this particular bill be moved to July 1st of 2024.
Got a motion, got a second? All those in favor say aye. Aye. All opposed, no. Thank you. All right. Is there a motion to roll these two amendments together? And a second. All those in favor say aye. All opposed, no. I'm hungry. All right. We are now voting on House Bill 908. All those in favor say aye. Aye. All opposed, no. Ooh. All right. Clerk, will you please take a roll call vote?
Representative Carringer. Carringer votes no. Representative Davis. Yes. Davis votes aye. Representative Doggett. No. Doggett votes no. Representative Farmer. Representative Fritz.
No.
Fritz votes no. Representative Glenn. No. Glenn votes no. Representative Hardaway. No. Hardaway votes no. Representative Howell. Howell votes no. Representative Johnson of Knox. No. Johnson of Knox votes no. Representative Lamberth.
Yes.
Lamberth votes aye. Representative Moody.
Yes.
Moody votes aye. Representative Russell. Russell votes aye. Representative Towns. Towns votes no. Vice Chairman Gillespie.
Yes.
Gillespie votes aye. Chairman Holsey.
No.
Chairman Holsey votes no. Mr. Chairman, you have 5 ayes and 9 nays.
Okay, the bill fails. All right, is there any other business for this committee?
Item 5. Go back to item 5. We gotta send it to GovOps.
There is one more piece of business.
Motion to reconsider.
Motion to reconsider our actions on 1663, on where we send the bill. All right, I said we were sending it to finance, we're not, we're sending it to GovOps. So I just want to make that clear. All right, any other business for the committee? All right, I appreciate your persistence.
Item number 7 was rolled 1 week.
Oh, we did not address item number 7 on the calendar, it's rolled 1 week. All right, do I hear a motion to adjourn? So moved. Dismissed.